For most of recorded history, when we were dead as human beings, we were dead. Our heart, our lungs, our brain all stopped at about the same time. There was no state statute defining death anywhere. There was no common law definition of death. We didn't need to tell the law to tell us what death was. Death simply existed. Technology has changed that. Think of this. From the year 1900 to the year 2000, so 100 short years of human history, life expectancy in the United States for an adult has gone from 43 years to almost 80 years. It's given every one of us in this room an extra adult lifetime. Julian Simon, well-known economist, calls that the single greatest achievement of mankind. Subjective, obviously, but it is pretty remarkable when you think about it. But with that progress has come responsibility, because the idea of nature taking its course has fallen by the medical technological wayside. Most dying in this country happens in institutions, most as a result of some kind of decision. And the newspaper headline, which says new heart drug promises huge decrease in heart conditions, could just as easily say new heart drug promises huge increase in frailty and dementia. Because if you plug a hole in the dike here, a leak springs over here, and the water still is all going to the sea. But from my point of view, I think I'll take the extra 20 or 30 years and just get a little better at talking about how we navigate at the end. You know, we have child rearing classes, we have birthing classes, we have Lamaze classes to learn how to breathe, we have marriage enrichment classes, and yet when we come up against a topic that we're all going to deal with, we suddenly shy away and draw in, and we're afraid to have that discussion. And the technology is changing and it's complicated, but the discussion is really the kind of discussion that lawyers often have. It's about basic human questions, and in this area it is, why are we all here? What's the purpose of medical technology? When can that serve us? And when does it not? And it wasn't long ago that we didn't ask these questions in our culture. I'm a baby boomer. My parents' generation are really the first people to ask what, when you think about it, is a very profound question. Might I want to say no to this doctor who's here to help me? New question, profound question, and a complicated question in many ways. All right, two kinds of pieces of paper have grown up over the years that go along with this talk. The first one, the one that most people, whether lawyers or lay people, if they haven't thought about these issues at all, they've at least heard these two words together and have some idea of what they mean, is a living will. One lawyer in Chicago, about 1970, seeing the beginning advance of this medical technology, had what was then a pretty radical thought. As I said earlier, what if I might want to say no to my doctor, but I could not? He came up with the idea of a living will. He knew there was a way in the law that we could write down on a piece of paper what happened to our stuff after we could no longer speak, after we died, through a document called a will. That was very well established. He came up with the idea of writing down, if I'm in a coma and I'm not going to emerge, I don't want the doctor to use a respirator for an extended period of time. He wrote a law review article about that idea in the Indiana Law Journal. We started to have that debate. 1976, California became the first state to pass a living will law. Through the 80s and 90s, bless you, other states followed suit. More recent in the law are documents that go by different names in different states, but they're all roughly the same. The power of attorney for health care, where rather than trying to write down, if I have these conditions, I want or don't want this treatment, you simply write down, if I can't speak about my medical care, here's the person who speaks for me. And different states have different formalities, but that's the basic document. Often, of course, these pieces of paper do work, but we've got study after study now in the medical, nursing, social science, and even the legal literature, which suggests that far too often what we write down simply doesn't work the way we think it's going to. So the coaching point I take from all of this, particularly for lawyers, is this. The law can give us rights and can give us forms and structure and guidance, but the black and white of the law can only go so far, and it's only so effective in navigating all of the gray that is serious illness and dying in the modern day hospital. This talk, it's not dark and sinister and macabre and something to be avoided, and if you have the talk with your clients and with your family and your friends upstream from illness at a time when everyone's relatively healthy, that discussion is a gift. And I think as lawyers, we actually have a special societal responsibility to take the initiative in having that discussion. So